Thank you all for joining today. We're going to be talking about the shared responsibility penalties and some affordability strategies. Also, in addition, on this particular webinar, we're going to talk about the enforcement delay that goes along with the penalties. Of course, when we put the list of seminars out originally, that was prior to the enforcement delay being enacted. That was on July 2nd. And so in this webinar, we're going to talk about the penalties. We'll go over them in some specifics because even though they are being delayed, they don't go away permanently. So we'll talk about that, and we'll also talk about the delay, as I've said, in particular because it's a little unclear exactly what is being delayed. We'll talk about what's actually being delayed and what isn't being delayed, probably more importantly, what isn't being delayed as we go forward into 2014. So like many of you, when I was first reading the rules and we got the regulations with regards to the Affordable Care Act and the penalties, I pretty much felt like this. I'm like, you've got to be kidding me. You know, if these penalties didn't put you over the edge, then the PCORI fee and the transitional reinsurance fee and the maybe soon to be implemented Cadillac tax were enough to put us all over the edge. But then, of course, we did hear about the enforcement delay, and that gives us some time to learn to work within the confines of our plans and the penalties. Our recommendation here at MedBen is to use the 2014 plan year as a trial and error time, as a way to test how your plan will work in the new world, to do things the way we're supposed to do them in 2014, and to see if we would have had penalties given that, so we know where to close those holes when the penalties become enforceable in 2015. So again, we're going to talk about the penalties, what some of us call it player pay. You know, if you've heard me speak before, I call it pay or pay or pay, because generally there's, you know, everything costs money. There's no option here where we just get to go along and not actually spend some money. So let's jump right in and talk about the penalties. In particular, who has to pay the penalties and be responsible for determining whether or not you're in a situation where they can be assessed against you as an employer. Penalties are applicable only to applicable large employers, and applicable large employer is a defined term under healthcare reform. Those are employers that have at least 50 full-time equivalent employees. Last week we went over how to count employees to determine whether or not you are an applicable large employer. So I'm not going to go into detail about that, but suffice it to say, if you have more than 50 full-time equivalent employees, then the penalties will apply to you because you are deemed an applicable large employer. Again, full-time is defined as 30 or more hours per week or 130 hours a month, for which you're paying an employer or they're entitled to be paid, like paid time off, sick leave, vacation time, that sort of thing. We use a common law definition of employees, and we have to count all the employees of the a control group that the employer may belong to. And so those are the types of employers that the penalties then apply to. We don't count hours of people who worked outside of the United States. And there are safe harbors for counting full-time going forward, and we're going to do a whole session on those. I believe it's next week with regards to using the measurement periods in that safe harbor. So that's who has to play. So if you are playing, if you're a large employer, you have a choice to make, and the choice is, do I offer coverage to a certain segment of my population, or do I pay a penalty? When it comes to the penalties, they are segregated into two categories. The names here are the names I've given to them. One is the greater penalty and the other is the lesser penalty. There's There are divided that way because of the total amount you'd have to spend under each penalty, not because of the per employee amount. The greater penalty is actually $2,000 per employee, and the lesser penalty is $3,000 per employee. But the greater penalty is only charged for all of your 30-hour employees at one time. It is never assessed on a single employee basis, where the lesser penalty is only applied on a case-by-case, individual-by-individual basis. So those are the two penalties we're talking about, and we're going to go through each of these in some detail here so that you understand how they operate with regards to you and your health plan. If you are an applicable large employer, then you are required by law to offer coverage or pay a penalty. Those are the two options. While there's no real requirement under health care reform for any employer to offer coverage to its employees, if you're an applicable large employer, if you don't offer, because that's your choice of course, if you don't offer the coverage to all 30-hour employees and their dependent children to age 26, then you will pay a penalty for that. If any of the individuals who are your employees go to the exchange and get federal subsidies to buy coverage under the exchange. Now that's a mouthful, and those of you who I've talked with about this in the past, you'll know that none of the penalties actually are assessed against an applicable large employer unless an individual, one of your employees, goes to the exchange and is able to get a federal subsidy, get money or credit from the federal government to buy coverage under the exchange. The penalties are not automatically assessed simply because you haven't offered coverage with respect to, for instance, the greater penalty in this case. So in order to avoid the greater penalty, you do have to offer coverage to all of your employees who are working 30 hours or more per week and their dependent children to age 26. You'll notice that it doesn't say you have to offer coverage to spouses. That is not part of the requirement. If you offer coverage to employees only, then you are not meeting the offering requirement, and despite the fact that you are offering coverage to just your employees, you will owe the entire penalty, again, if one person goes to the exchange. If you don't offer that coverage, it is $2,000 per year collectively for all of your employees who are working 30 or more hours a week. And again, remember that that's offering to employees who are working 30 hours or more per week, regardless of their job classification. So if you currently say that 30-hour or 32-hour employees are part-time employees, you still have to offer them coverage, even if you don't offer them coverage today under your current definition of full-time employee. We kind of went through some of that last week, and we'll go over more of that in the coming weeks. But the reason I call this the greater penalty is because you do owe it for every single individual, every single employee who works for you for 30 hours or more a week, even if just one of your employees goes to the exchange and gets a subsidy. Now, the actual offering requirement is this. You have to offer it to substantially all of your 30-hour employees. There is a rule that says that you won't be assessed the penalty even if one of your employees goes to the exchange and gets a federal subsidy, if the number of people that you have failed to offer coverage to is less than 5%, 5 employees, or the larger of 5 employees or 5%. So the federal government intended this caveat to be one to allow you to make a mistake, to if you've made an error and accidentally failed to offer coverage, then you have a little of a cushion, a little wiggle room, so that you don't cause yourself to accidentally be assessed a very large penalty. We have some employers, when we talk about affordability strategies, we have some employers who their population between what they currently define as full-time and 30 hours is around 5 employees, or 5% of their total population. And so in that case, they're intending to use the 5% cushion not as something to account for clerical errors or accidents, but actually to intentionally not offer coverage to that 5%, because that's their wiggle room, and they won't get a sudden penalty because 95% of their employees will be offered coverage. But that's a case-by-case scenario. We talk about how you use these penalties to your advantage. I think the biggest thing to remember as you're looking at your particular scenario is not to be scared of the fact that it's a penalty. It's not think of it more as an excise tax. I mean, penalty bears sort of certain connotation that sounds like, I'm in trouble, bad things are going to happen. There are no penalties beyond the dollar amount here. There's no excise taxes. There are no civil violations or lawsuits pending or anything like that. There isn't even causes of action for your employees to sue you under healthcare reform if you don't offer them coverage. What happens is you would pay the money. So if you're looking at how you are going to manage offering coverage to all 30-hour employees and their dependent children to age 26, you can use this 5% to some advantage possibly in offering the coverage to 95% of your full-time employees. That said, if you decide to use that route, which is perfectly fine, bear in mind that you use up some of that cushion for mistakes. So you'll want to make sure that you are actually offering that coverage to all 30-hour employees. Now, we've talked about that word offering a couple times now, and what does it mean? You have to offer minimum essential coverage to your employees. The fact that you're a health plan employer sponsor is an offer under healthcare reform. The other things that are shown on the screen right now are other things that are considered minimum essential coverage, but just by the nature of offering a policy as an employer, you meet the definition of minimum essential coverage, whether it's through a fully insured policy in a carrier, a group policy, or whether you self-fund, you're still offering employer-sponsored coverage. And as long as it isn't accident-only coverage or a disability plan that you're trying to say is your health care offering, then you're meeting that definition. So there's no issue there. When we talk about offering as well, there's no requirement that your employees accept the coverage. In order to avoid the penalty, they have to be offered the coverage. Now, health care reform and the Affordable Care Act don't allow you, in fact, it's a violation of the rules, the regulations, if you incentivize your participants to not take your coverage and not go to the exchange and look for coverage there, similar to the rules in Medicare where you're not allowed to incentivize someone to go on Medicare and not on your plan. But outside of that, all you have to do is offer the coverage to them. If they don't want it, then you've still met the requirement. You don't have to enroll every single person that's working 30 hours or more in order to meet this requirement. So that's one of those issues that comes up from time to time. One thing with regards to that, again, when we're talking about strategies and the greater penalty is because one person could go to the exchange and throw off the entire entire balance with regards to owing a penalty, say, you want to make sure that you get any declinations in writing. So if your enrollment form right now, whether it's for a fully insured policy or a self-funded plan, doesn't have a place for your employees and their dependent children to decline coverage, you'll want to make sure you get that. And I would suggest strongly that you have a place where the employee can sign that he's declining coverage on his or her behalf as an employee, and he's also declining coverage on behalf of his dependent children. While some dependents can be over the age of 18 and thereby adults and could sign the form themselves, with regards to declining coverage, because the dependent can't get coverage by himself on the plan, the employee also has to enroll. I think it is sufficient for the employee to decline coverage for the dependent. But you want to make sure that you get both of those declinations, because if an individual does go to the exchange and maybe gets confused about what was offered him or whether coverage was offered to him, and the exchange comes back to you and says, we have information from your employee that you didn't offer coverage to him, you'll want to be able to prove, in fact, that you did offer coverage, including offering coverage to his dependents, and that way avoiding the application of the entire penalty back on your plan. So when we talk about the greater penalty, we're talking about the $2,000 amount applied to all 30-hour employees in the event you fail to offer coverage to all 30-hour employees and their dependents to age 26. And then again, it's only applied if one person goes off to the exchange. That concept of having one person go off to the exchange also applies to the lesser penalty. Well, what is the lesser penalty? The lesser penalty kicks in if the coverage that you are offering is not affordable. And when we talk about affordability, there's really a two-pronged test. So when I talk about affordable with a capital A, I'm talking about both requirements for the employer's plan to be affordable. Another thing quickly to note is that you would never get assessed both the greater penalty and the lesser penalty. The greater penalty is only going to be assessed if you don't offer coverage, and the lesser penalty is going to be assessed if you don't offer affordable coverage. And there's a rule in the lesser penalty that if your plan, let's say you offer to employees only and not to dependents, and you get charged the greater penalty, then you've basically paid the lesser penalty for any of those individuals that might go to the exchange and get exchange coverage. So the lesser penalty, again, is a $3,000 per head penalty. And again, it has to do with the policy that is actually offered to the participants. So the lesser penalty has to do with capital A affordability. And affordability with capital A, the general affordability rule has two parts. One is minimum value, and the other is whether or not the employer's coverage is affordable with a small a. And I want to make sure that I clarify that if you don't meet both tests from a policy or a plan situation, if both tests aren't met, then the penalty kicks in. When you think about minimum value and you think about affordability, we are really talking about the amounts of money that an individual has to pay out under the plan. So the minimum value test really speaks to the amount of money that the participant pays in benefits under the plan, so deductibles, coinsurance, the amount of money that the employee is responsible for under the plan. Whereas the affordable part of the test has to do with how much it costs him to get access to that coverage, the contribution he would have to pay. The minimum value test says that you pass that test as an employer and your plan has minimum value if, as an employer, you're covering 60% of the cost of the benefits under that plan. Now, the majority of employer-sponsored health plans do pass that test. If you're fully insured, the responsibility for making sure that there's minimum value in that policy rests with the carrier. So if you purchased a group policy from a fully insured carrier, it's going to have minimum value because they wouldn't be able to get it approved by the State Department of Insurance or the exchange to sell that policy if it didn't have minimum value. So in the fully insured world, a minimum value plan, these are where you get the metal levels, or a 60% plan is a bronze plan, a 70% value plan is silver, 80% is gold, and 90% is platinum. Those are terms that we use in the fully insured world. All of those meet minimum value, and those are the policies that are being sold on the market, or will be sold in 2014. They're currently in the process of being approved. If you're self-funded, then you have to determine whether or not your plan actually covers 60% or more of the costs and benefits. And while that sounds sort of like a no-brainer because you think about your plan, maybe you have an 80-20 plan and a relatively low deductible, certainly as an employer you're paying out more than 60% of the benefit, and in most cases that's true. But unfortunately, in order to meet that test from a self-funded perspective, you have to get your plan to pass through the minimum value calculator. And we're going to spend time next week looking at the minimum value calculator and discussing how it works and how you get your plan out of the minimum value calculator with a 60% score or more. So, but know that that's the side of the test that has to do with the plan. The other side has to do with how much it costs the employee to get access to the coverage, the contribution that they have to pay to be enrolled on the plan. And this is the part of the lesser penalty that people talk about all the time. We talk less about minimum value, although it's equally as important because you also have to pass that test. But we talk a lot about the 9.5% of the employee's household income. That is truly the regulatory requirement in order to determine if an employee's, the contribution you charge an employee for the plan is affordable. And the test is, is the contribution they pay more than 9.5% of the employee's household income? Well, of course, as employers, we all went, whoa, nobody knows an employee's household income. That would be extraordinarily difficult to learn. The government heard your cry, and it came back with these affordability safe harbors. There are safe harbors with regard to minimum value, and we'll talk about those next week. With regards to affordability, the safe harbors fall sort of into three general categories, all of which pull the 9.5% as a percentage of the employee's wage, or what the employee is paid during a year, as opposed to their household income. We're allowed to use this during 2014. We actually have not heard whether or not this safe harbor will be available in 2015. So when we get to the end of the presentation and we're talking about what this enforcement delay really does for us, this is one of the questions that's still open. Are we going to be allowed to use the 9.5% against the employee's wage, or will we have to go back to the 9.5% of household income? But for 2014, in our sort of practice year, we can take an employee's W-2 wages for the calendar year. We can also use an employee's hourly rate of pay times 130 or a monthly salary amount, or we can use the federal poverty level that's published for 2014. Remembering that these are all 2014 tests, so when we're talking about the contribution we intend to charge in 2014, we're applying that against the employee's 2014 W-2 wages or their 2014 hourly rate of pay, neither of which we know yet, or the 2014 federal poverty level, which hasn't been released yet and won't be released until January of 2014. So when we're working through the affordability safe harbor and trying to determine whether or not our plans are affordable based on this test, it is truly nice to have that enforcement delay, because it's going to be an interesting exercise to determine whether or not the contributions that we offer to our employees are 9.5% or less than the wages that we might pay them in 2014, depending on how long they work and whether or not they get a raise and those sort of things. One of the things that I suggest to our groups is that you take your current contribution, think about how much you've had to increase that contribution from year to year. So you think about how much you might need to increase it in 2014, particularly if you're self-funded, and how much the cost of your claims have gone up or not, depending on your particular situation. And then you do the same with your wages. Most employers know what their standard wages are in different classes of employees. They also know whether or not they give a raise each year, or what the general amount of that raise is on a standardized percentage basis. So try to use some guesstimates for 2014, both with regards to contribution and with regards to wages, to find out which of your employees would fall out of affordability. Again, when we talk about affordability strategies, I would say don't be afraid of the lesser penalty. It's $3,000 per person for whom the federal government has given a subsidy and decided that your plan isn't affordable. And they're going to decide also based on some of this information. But in that case, if you're looking at your plan and you're meeting the greater penalty and you have to charge certain contributions in order for your plan to be viable, perhaps 5, 10 people fall out of the affordability test when you get to the lesser penalty. It's $3,000 a person. Perhaps it's less expensive to just budget $3,000 for 10 people, budget $30,000, rather than lowering the contribution for everyone, because we still have to maintain the rules with regards to discrimination. We can't charge some people in a certain class of employees one amount and other employees a different amount based on their wage. We could do it based on job class, but if you have everybody in one category of employee, let's say everybody's an hourly worker, we couldn't charge some of them more than others because we would be running up against some discrimination issues with regards to ERISA and some public health services rules. So maybe, though, it's cheaper just to charge everybody the higher amount and budget the penalties, and then see if the 10 people go off to the exchange. Maybe they want. Some of those people may get coverage under their spouse's plan. Some may have individual policies. You know, it's not a given. It's not a guarantee that simply because you have some employees that are being charged more than 9.5% of their wage that you're going to be assessed a penalty. Again, the penalty only comes into play if that person goes to the exchange, gets a subsidy from the federal government, and gets coverage under the exchange. All of those things have to happen in order for that penalty to be assessed back to you. With regards to the lesser penalty, we still have a lot of open issues. We don't necessarily know how to handle employees' change in employment status. So again, that employment status change may come with a wage change. How are we going to anticipate the affordability safe harbor and W-2 safe harbor if we don't know what's going to happen with an employee's change in status? We don't know really how to cover breaks in service, particularly unpaid FMLA. If we have to keep people on, if we have to count that. Right now, for instance, just on a sort of logic overlay on top of the regulations, which I understand is, you know, crazy because the government doesn't always do things in a logical way. But if you have an employee who is on your plan and has to stay on your plan because they're on FMLA, but goes on to unpaid FMLA, all of a sudden they may be in an unaffordable situation. You're going to charge them the same contribution you were charging them before, right, which was affordable when they were being paid a wage, but now it's unaffordable. It's unclear to us whether or not there's going to be regulation that will give us guidance through that unpaid FMLA time, or if the employee is allowed to go to the exchange. And maybe you'll pay part of a $3,000 penalty for a couple months or while they're on the unpaid FMLA and on exchange coverage, and then they come back on your plan and it's again affordable and you stop paying the penalty. These are questions we don't know the answer to. So we're still waiting on guidance on that. But in general, I think you look at the lesser penalty as a budgetary issue and a cost issue, the same way you will be looking at your plans in the coming year for how much you have to charge your employees for their contribution, and you budget accordingly. I think that's one of the things we can do. Again, not to be afraid of the lesser penalty or paying a penalty, because it's simply a payment of money and nothing else happens with regards to that. I wanted to remind you all, too, that there is a question function on the calendar, on the website, and I just wanted to make sure that you have any questions with regards to that. You can go ahead and ask them there. I did get a message that you're having trouble hearing me. I hope that has resolved itself. I'll put the microphone closer to my mouth. I do want to talk now a little bit about the enforcement delay and what was actually delayed. We did get transitional relief guidance in IRS Notice 2013-45. The things that are delayed in the enforcement delay that took effect in July mostly surround certain reporting obligations that employers are supposed to do and carriers were supposed to do with regards to how their employees were being covered and what sorts of minimum essential coverage they were being offered. Now, if you remember, we talked about the greater penalty. The offering was of minimum essential coverage, and that included some policies as well as employer-sponsored health plans, TRICARE, Medicare, Medicaid, those sort of things were minimum essential coverage. it was supposed to be that by now, in fact, probably prior to now, we were supposed to have regulations that instructed us as employers and insurance carriers as well on how to report information to the federal government that included things like our employees' Social Security numbers, whether or not they're offered minimum essential coverage, what their salaries were so that the employee household income could be calculated at the exchange level. All of that information was supposed to be reported out, and we were supposed to have regulations. Now, a couple of things happened. First of all, the federal government was supposed to, and is in the process of, but is not done, creating a mega database that will include all of this information. And it's a sort of scary notion that that's housed and run by the IRS, given the fact that the IRS has been under fire so much in the last few months with regards to some inappropriate actions. This database is being created, and employers and insurers are supposed to report into it. In the enforcement delay notice that came out from Treasury on July 2nd, they indicated that because employers were upset about all the information they were going to have to report out and how, that they were implementing this delay. And I find that quite interesting because we didn't even know what that was yet, so nobody had a chance to be upset about it. Although I'm not complaining, we got a delay, and that is helpful. Because the mega database and the reporting was what was going to run and trigger information at the exchange level as to what applicable large employers were really doing, i.e. were they offering coverage or not, and therefore had to be assessed the greater penalty, or was the offering that they were making affordable or not, and therefore they needed to be assessed the lesser penalty because that reporting and database wasn't in place. They also delayed the application of the penalties. Now, interestingly enough, that does not necessarily delay the work that you have to do or the offer that you have to make. There is nothing in the IRS notice that actually delays your changing your plan to offering coverage to all 30-hour employees. Again, it delayed the shared responsibility penalties, including both the greater and the lesser penalties. Those were delayed. In IRS Notice 2013-45, which is the delay notice, the IRS states that they won't assess the penalties during 2014. They don't use any good faith effort language either. So, it's sort of open with regards to how much you have to do. As an employer, each of you have to decide then, what am I going to do in 2014? How far am I going to go to complying with the offer of coverage and the affordability of coverage? Even though that wasn't delayed, the penalty that would be assessed to me if I didn't do it has been. And I think that's an individual decision that each employer needs to make. The IRS does intend the transition relief, or that delay, to be used as a period of time for employers to transition and adapt their plans to the new requirements. Not just the reporting requirements, but those requirements that were still in place with regards to offering coverage to all 30-hour employees, as well as making sure that offering is affordable. So it's important to remember that, again, it only delayed the application of the penalties. It didn't delay the work that we're actually supposed to be doing during that time. The IRS has also offered up that if you feel it necessary to voluntarily comply and report during 2014, once they've released that guidance, they'd be happy to take that information. I think that's something that we will wait and see what those regulations say before MedBen advises its clients to voluntarily offer up any reporting. We'll certainly want to get clarification and information about how that reporting is supposed to be made and how it can be changed if mistakes are made and things like that. But I do want to talk quickly about what is not delayed, because that's something that that is important to note. Even though the notice was silent about these things, I do not think we can make an assumption that silence means everything is delayed. Silence means they haven't said anything, and that's all. Things that are not delayed, one of them, tracking variable hour employees. As we move into 2014, again, we still have to offer coverage to all 30-hour employees. And that means that we still have to make sure that we are treating 30-hour employees as full-time, and anybody that works less than 30 and maybe working a variable hour schedule, that we're counting their hours to see if they get up to 30 at any given point in order to offer them coverage in the next stability period. And 2 weeks from now, we're going to spend some time with the measurement period, safe harbor, and the stability period and how we count those. But I don't think this is something that you take off your plate right now. I don't think employers should say, well, I'll just worry about counting employees. I think 2014 is a great year to start thinking about how to count your employees, how to track their hours worked, to determine what measurement period you will use. Another thing to note is that we've had some transition relief already granted to employers with regards to some of the rules that have been put in place. And that transition relief was specific to 2014 only. We cannot assume that the transition relief that would be available in 2014 will extend into 2015. And this is one of those good examples. We were told that we could have a shorter measurement period in 2013 and a longer stability period in 2014. If you recall, a measurement period and a stability period have to be equal. So if I have a 12-month measurement period, I have to cover people on the stability period for 12 months, the coverage period for 12 months. But in 2013, because the law didn't come into effect until several months into 2013, we could, for instance, have a 6-month measurement period in 2013, but a 12-month measurement in 2014. That transition relief is not does not extend into 2015. So when we start 2014, we have to be counting for an entire measurement period. So you want to plan for that. Don't plan for a short first measurement period simply because it would be your first measurement period. That short measurement period was only available in 2013. That won't extend into 2015. So we'll talk about that in a couple weeks, but make sure you understand that some of the transition relief that was granted to us because we were coming into this in 2014 for the first year is not extending into the 2014-2015 year. The other thing we have to do is all of the changes that we have to make to our plan, removal of annual lifetime dollar maximums, elimination of pre-ex, making sure that our waiting period isn't longer than 90 days, changing our out-of-pocket limits to no more than $6,350. Those things still apply in 2014. They take effect on your first plan year in 2014. The law read that way. That's not a problem. We can still go forward with the first plan year in 2014, but that doesn't get delayed until 2015. Those changes still need to be made in 2014. When we talk about the 2014 transition period for the penalties, if you recall, originally the penalties were to be applied to all employers, regardless of plan year, on January 1st, 2014. That's the way the law was written. The penalties would apply to every plan, regardless of your plan year. So if you were an April 1 plan year or a July 1 plan year, you still had to pay penalties, starting in January 1 of 2014. Then the government came along earlier in this year and said, hey, if your plan was already in existence in December of 2012, we will allow you to not be subject to the penalties until your first plan year in 2014. And so we had this transition relief. That has not been extended based on this enforcement delay. So now the government has said in the enforcement delay rules, in the IRS notice 2013-45, that the penalties will apply January 1, 2015. They won't roll to your next plan year. At least we haven't gotten that information from them yet. That means that as you work into your 2014 plan year, if you are not a January 1 calendar year plan, you will need to make changes to your plan in 2014 to make them, to offer coverage to all 30-hour people and to make it affordable so that when your plan rolls across January 1, 2015, you are meeting those requirements. Otherwise, you could be assessed a penalty. The penalties will not be delayed to the plan year in 2015. I hope I'm making that clear. It's a really sort of interesting caveat, but that transition period which allowed us to apply penalties the first day of any plan year in 2014 has not been extended to 2015. The penalties will apply to your plans, all of your plans, regardless of the plan year beginning date, on January 1, 2015, according to the delay enforcement guidance that we received. So we need to plan for that in 2014. The individual mandate does still apply, though, January 1, 2014. So all of us as individual citizens are supposed to have coverage on January 1st, 2014. If we don't, we pay a penalty. We pay that penalty on our 2014 taxes, which we will be preparing in the first quarter of 2015. The other thing that hasn't been delayed are the exchanges. The exchanges are still due to be open October 1st, with an open enrollment period between October 1st, 2013 and March 31st, 2014. So those are still open regardless of the fact that the penalties will not be assessed to you if your employees enroll on the exchange and get a subsidy from the federal government. Also, the federal subsidies aren't being delayed. They will still be available. Subsidies come in two forms. They come in either a premium tax credit, which is an actual credit that you take on your taxes when you do them for the first time. It will be in January of 2015 for your 2014 personal tax year. Or you could get a reduced premium from an exchange carrier, but those will all still be available in 2014. And the notices that we have to put out as employers to our employees telling them about the exchanges also have not been delayed. Now, those exchanges have information on them where we need to tell our employees whether or not our plan has minimum value, whether or not we offer a plan, whether or not our plan has minimum value, and whether or not it's affordable. So we'll still need to make some assumptions with regards to our 2014 plans so that we can get that exchange notice out prior to the exchanges opening October 1st. Those are still due. The PCORI and transitional reinsurance fees are still due. The first ones are due this July. Our first webinar was about that fee. The transitional reinsurance fees are first due in November of 2014. Those have not been delayed and are still on track to be collected. And another thing I just want to point out is that the 2015 penalties may not be the same as the 2014 penalties. The regulations indicate that the 2014 penalties were $2,000 per employee on the greater penalty and $3,000 per employee on the lesser penalty, and that each year the government will decide how much those penalties will go up. That's already in the regulation. So 2015 is a new year. The government may hold the penalties at these levels, but they also could increase them. So I think we need to just be aware of the fact that it won't be in 2015 that we can assume that the penalties will stay the same. The law allows them to go up, and that would be the first year that they could increase them, and they may do that. So I think we need to be aware of that as we move forward. So that's the end of my formal my formal comments. I hope that's been helpful. I will wait to see if anybody has any questions. Again, you can type your questions in and ask them of me that way. I hope that the sound got a little better. So if you could, I'll just give a little bit of time. Again, many of you that I see on the attendee list, I know have attended some of our MedBen seminars before, and we've gone over a lot of the same information. I think that as we start thinking through what the delay means, that's where we need to start trying to determine whether or not, deciding what kind of changes we're going to make in 2014 and which we might delay. I do have one question. Our plan is an 8/1, an August 1. So do we need to offer coverage or less than 90 days by 8/1/14 or 1/1/14? Okay, so if you're in August 1st, with regards to the plan changes, the 2014 plan changes and the 90-day waiting period, that change would have to be made August 1st, 2014. The plan changes, the removal of all the annual dollar limitations, removal of pre-ex, making your waiting period to 90 days or less, routine coverage of care that's associated with the clinical trial. Those sort of things will be made on your 2014 plan year. So if you're in 8-1, those will be made 8-1. The problem is that we use your plan as an example. The 8-1, when you are making your plan changes next August, you'll want to make sure that you make the changes, particularly if you're self-funded, that you make those changes in order to have for your plan to offer to all 30-hour people and to have it be affordable on 8-1 so that when your plan year rolls over January 1st, 2015, and you can be assessed penalties, you won't be assessed penalties you weren't already anticipate in, or had planned on being assessed. You can't wait till August 1, 2015 to worry about whether or not your plan is in compliance so you don't be assessed penalty, because the government hasn't delayed it or said that the penalties will apply by plan year in 2015. They said they'll apply January 1, 2015. So your plan starts 8-1, you're going to want to make those changes, because when you get to January, if you make the changes then in order to be compliant and you're self-funded, your stop-loss carrier may not allow you to make those changes mid-year, particularly if you're dropping eligibility down to 30 hours where you hadn't had that before. You want to make that change 8-1 and get the stop-loss policy on board so when your plan rolls around to January 1st, you are compliant from a penalty perspective. Otherwise, you'll run the risk of being assessed a penalty starting in January. The question, we can find little information about the exchange. Well, that's because if you're in Ohio or Indiana or Michigan, and this sort of 3 states, we're part of the federal exchange, and there has been very little information put out. We've gotten these exchange notices. We've gotten I have a sample application now, or what an individual would be asked to fill out either as a single person or as a family to get exchange coverage, but no information about how to access information about the exchange online. Remember, access to the exchange is sort of a virtual thing. You do it online. In Ohio, we are only just now seeing information about how Ohio intends to train navigators. So until they've trained those people, they won't even be able to tell us how they're going to operate. I mean, it's a very valid question. Here we are sitting at the end of July, and we still have very little information about what an exchange is going to look like in the state of Ohio. Now, Kentucky is operating its own exchange, but they are still in the process of putting it together. We talk to them sort of periodically. They make some changes, and so they may be a little farther along than the federal government, but there's still very little information about that. I'm starting to work on now for our clients sort of an employer handbook with regards to healthcare reform in 2014, and the exchanges. Right now it looks a little thin because there's not very much information that I can include with regards to the exchanges, but I'm hoping that as we move forward, we can get some more information in there, both for you as an HR person and an employer to answer questions, and also some information that you can hand to your employees. I think one of the interesting things as an HR person now is how to answer the questions when people come to you about the exchanges. One, we don't know very much. We want to be helpful to our employees, but we also don't want to be, well, I think it's an employer decision about whether we want to be encouraging people to go to the exchange or not. Certainly, if we intend to offer coverage as opposed to paying the penalty, we want to make sure that we keep our participation levels up on the plan. People could go off to the exchange. Your plan could be absolutely affordable and you wouldn't pay a penalty, but if people go off to the exchange and decide they want to buy that coverage even though they won't be getting a subsidy, it lowers the participation on your plan. So if you're fully insured, you might not meet the carrier's participation requirements. You might have that problem with the stop-loss carrier as well. So You know, I've been starting to try to think through how we address those questions and send them back off to navigators who are really the appropriate people to answer those questions in any event. I have another question. How do we measure hours to determine over 30? We did an entire seminar on that last week, and I can certainly talk with you offline. It's somewhat complicated. We can also, if you want to email me, my email address is here, or call me. I can get you a copy of that, the audio and the presentation from last week. It's a little complicated. Certainly, there's a difference between how you count people if you're trying to determine if you're a large employer and how you count people if you're already a large employer. I will tell you that it might be next week. Let me look. Let's do a plug for next week. In 2 weeks, on August 8th, we're going to be spending a bunch of time with the measurement period and counting hours, how you count hours if you are already a large employer and you're trying to determine who would be eligible for coverage using the measurement period based on your variable hour population. We'll be spending a bunch of time on that. So tune back in on August 8th for that. If you are looking for hours to be counted to determine if you're a large employer, we can get you the broadcast from last week, July 18th, which goes over that in greater detail. We can, of course, talk offline, not a problem. Okay, any more questions? I'll give it a couple more minutes here. Okay, I don't see any more questions. I will tell you that next week on August 1st, we will be working with the minimum value calculator and some of the minimum value safe harbors. Talk a little bit about skinny plans, not a lot, but some. If anybody's heard that term. We will have the calculator up online. I'm hoping that we can toggle back and forth between the presentation and the calculator and show you some of the minimum value calculator and how we've gotten it to work. That's next week. On the 8th of August, we do measurement periods. The 15th of August, we'll talk about exchanges in your HR department and how you can go about helping your employees understand what's going to happen, at least to the extent we know. And then on the 22nd, we'll talk about the new wellness rules, and in particular, how those wellness rules apply to your plan offering, to your minimum essential plan offering, and whether or not, how we treat those from an affordability perspective, because if you have a wellness plan and a non-wellness plan, how we fit that into this whole penalty scheme to determine affordability and that sort of thing. So not seeing any more questions, I'm going to go ahead and say goodbye for today. I want to thank you all for attending. Again, my contact information is there. You can call me at any time, email me if you have questions or need clarification. Again, I thank you very much for your time today. Everybody have a wonderful day and enjoy the weather. Thanks so much.